This is a very good morning to you. Uh, Being outstanding students of HR, it is imperative that you should be familiar with Industrial Disputes Act 1947. This is an important law. The nomenclature of this law is Industrial Disputes Act. I do not like personally. I wish it should have been Industrial Harmony Act or Industrial Coherence Act to bring more positivity. The nomenclature itself says it is about disputes. Anyway, so let us understand the basics of this law. Just imagine about a factory where workers are working. If they have fight among themselves or if they have a fight with the factory manager, whom to contact, how to resolve the dispute. There was no such law before 1947 for such matters. And now in 1947, a new law was enacted, Industrial Disputes Act 1947. This act was passed on 11 March 1947. It applies to whole of the India and it covers disputes between workers and management, disputes related to working conditions, works related to factory conditions, etc. An important definition under the Act is industry under section 2J. What is an industry? Is it only factories? The answer is no. Industry means, of course, factory, but it means any place where there is systematic activity done with the cooperation between employer and employee. So then it is industry. So it may be a factory, it may be any other place where people are working together. It includes factories, shops, hospitals, educational institutions, transport services, even government departments are also covered under this act. Let us look at the Bangalore water supply case versus Rajappa 1978 case. What was the matter of the case? The Bangalore Supply and Sewerage Board fined some employees for misconduct. The employer went to labor court. The board said, we are not industry. We are a statutory body providing essential services. The labor court cannot hear this. But what was the Supreme Court's decision? The Supreme Court gave very wide meaning of the industry. There was a 7-judge bench led by Krishna Iyer. He said there are triple tests. First, is there systematic activity? Second, is there cooperation between employer and worker? Third, is it for production of goods or services? If the triple test is found okay, that means it is industry. The common man has to understand and apply the law. We must give clear definition. The court held that even government bodies cannot, even government organizations can be industry if they do commercial work. Right? So this case is very important. It gives us a fundamental understanding of this industry, section 2J. So it's a very wide definition and therefore it covers industry and various organizations. Next we come to strike. It is defined in section 2Q. What is a strike? Any cessation of work by workers is called strike. It is of various types: go slow, pen down strike, tool down strike, hunger strike. When workers say we will not work, they are on a strike. So it can be like this. Strike is by workers and the management resort to lockout under section 2I. When management refuse to give job to workers, when they refuse to give employment to the workers, then it is called lockout. So lockout is a weapon by the employer and strike is a weapon by the workers. Both are temporary, both are different from closure. Closure is permanent, strike is temporary, lockout is also temporary. So in strike, workers refuse to work. In lockout, the employer refuses to give work. Another important piece of definition here is layoff. It is given under section 2 KKK. Layoff means when employer refuses to give work to a worker whose name is on the rolls on the basis of shortage of coal, shortage of power, shortage of raw material, accumulation of stock, breakdown of machinery, natural calamity, then this is called layoff. Layoff is different from layout, lockout. Layoff is different from closure. Layoff means the employer says, I am unable to give you a job today because today I do not have raw material, or I do not have power, or I do not have coal, or I do not have the required material, or my machines are not working, or there is some natural calamity. Then it is called layoff. In case of layoff, half of the wages are paid. The employer just cannot give work temporarily. If the worker has completed 1 year of service, they get 50% of the basic wages and the earners allowance during layoff. Retrenchment. Retrenchment is defined in section 2. Retrenchment means employer terminates worker services for any reason other than punishment. Retrenchment is not voluntary retirement. Retrenchment is retirement on reaching is not retirement on reaching age limit. Retrenchment is not termination due to ill health, right? Retrenchment is not the termination of job as punishment. So, a retrenchment takes place when employer terminates the services of workers for any reason other than punishment. Then it is called retrenchment, right? Now we come to a closure. Closure is defined in section 2C. Closure means permanently closing the whole business. So in case of closure, the work, the factory is closed down. The closure is different from layoff. Retrenchment. Layoff is temporary. Retrenchment is permanent. Closure is also permanent. In layoff, we are unable to give work due to some reasons. What are the reasons? The reasons could be you don't have raw material, you don't have power, you don't have electricity, you don't have machines, good conditions, or there is some natural calamity. So that is called layoff. Closure is when you close down the business completely. Retrenchment is when you ask the worker to terminate his job, not as a punishment but otherwise. Then it is called retrenchment. Question is who can raise an industrial dispute? It can be done by worker, it can be done by employer, it can be done by union. So dispute can be raised by any of them, right? A group of workers or a union or work management, anyone can raise dispute, right? So disputes should be related to the factory, the industrial matter. It may be related to the general industrial system, or it cannot be personal events. Disputes about dismissal, discharge, retrenchment, termination, closure, etc. are also industrial disputes. They are not personal matters, they are industrial disputes. What is the machinery for industrial dispute? First of all, we have in a works committee in every factory. If a factory has 100 or more workers, the government can order the employer to form a works committee. A works committee consists of equal number of representatives from employer and employee, right? The workers' representatives are elected or nominated, right? The function of the works committee is to promote peace, good relations between employer and employees. It discusses matters of common interest. It solves differences between workers and management. So, a works committee can be one way. Works committee means a committee of worker management. Both of them send their representatives, sit together and try to solve the problem. Second is conciliation officer. Conciliation officer is appointed by government. It is the task of the conciliation officer to mediate between the two parties and arrive at a settlement. It can investigate the dispute, it can call a meeting, it can ask for a document, it can do anything to bring parties to settlement. So conciliation officer is like a judge. He sits between the two parties, listens to them, and helps them to arrive at a settlement. There are two types of settlement: bipartite, which is person arrangement, and tripartite, when the conciliation officer is involved or government is involved. That is tripartite. Oswald Agro Limited case. Oswald Agro had a factory due to condition problems. They wanted to close it. On June 14, 1996, they signed a settlement with the workers during conciliation, but they had taken government permission for closure as required by law. The question is, can a settlement between employer and worker override the permission for closure? Because they had taken permission from the government to close the factory, and now they have agreed for a settlement with the workers. The Supreme Court answer said no. Section 25(9) and 25(4) of the Act are mandatory. They must be followed. A settlement cannot bypass law, right? A settlement between workers and management cannot bypass the law. If the closure itself was illegal because proper permission was not taken, then the settlement arrived at based on that closure is illegal, right? So settlement is binding, but it cannot use something illegal, right? So if there is any matter, we have to follow the law, and this has to be done. Board of Conciliation. Board of Conciliation means board of just like conciliation officer is a simple person. A board of conciliation is a group of conciliation officers who are working together. They are a board that is called board of conciliation. There is a chairman plus 2 or 4 members, right? There are equal number of representatives from workers and management here, and this board investigates the dispute fully and tries to bring a settlement to the dispute, right? So this is called board of conciliation. Then we have board of inquiry. Board of inquiry is when the government appoints a board of inquiry to investigate any industrial dispute, right? So it's a fact finding body. It prepares the report and gives to the government. Then labor code. The government appoints labor code in every city, and the labor code can handle any matter related to industrial dispute. The labor code can handle legality of the orders under Standing Order 25, Standing Order Act, application and interpretation of standing orders, charge the dismissal of workers, withholding, withdrawal of the concessions, illegality of strike or lockout. So any of these matters can be handled by labor code, right? The labor code is headed by a judge. The judge must be of the level of high court judge or district judge for at least 3 years and should have had judicial office for 7 years. So that should be his qualification. Then we have industrial tribunal. Industrial tribunal is having wider jurisdiction than the labor code. They can handle wage, compensation, hours of work, leave with wages, bonus, grade, rules of discipline, rationalization, retrenchment, closure, etc. So there is industrial dispute, industrial tribunal, right? Then we have national tribunal. If there is a matter of national importance, central government can constitute national tribunal for that particular matter. On which matter? The matter which is of having national importance, or the matter which affects industrial establishment in more than one state. Then this matter is given to national tribunal, who undertakes the examination of the matter and gives the judgment. Then arbitration. Arbitration is like mediation or like conciliation in that way. While conciliation officer works on behalf of the government, board of conciliation works on behalf of the government and tries to bring the two parties settlement. Similarly, Similarly, an arbitrator also tries to bring the parties to settlement. Instead of going for government authority, employer and workers can agree to have an arbitrator of their choice. Arbitrator here is acceptable to both parties, right? So he listens to both the parties and helps both the parties to bring an settlement. Next, regarding procedure, section 9A, change of terms of conditions of job. An employer cannot change service condition without giving proper notice. Any change in wage, allowance, hours of work, leave of work, etc. will require proper notice under section 9A. Notice period is minimum 21 days, and the purpose of the notice is to give workers time to give their objection or to negotiate before the change takes place. Under section 10, when conciliation fails, the conciliation officer can send a report to the government, and then government can decide whether to send the matter to the court, to the tribunal, or to national tribunal. The government's role is administrative, not judicial. They only need to form an opinion that a dispute exists and apprehend it. Then they don't have to take judgment. They have to refer the matter to labor court or tribunal or to national tribunal. Next, there is a case discussion. Premium Transmission Private Limited, a company in Aurangabad, had workers contractors. The workers union said contract system is fake. They wanted to make the workers permanent employees. They went to conciliation officer in 2019. The conciliation failed. The deputy labor commissioner referred the dispute to industrial court. The company challenged it. They said union did not first send a charter of demand to the company. The workers were contract workers, so employer-employee relation did not exist. But the Supreme Court rejected both the arguments. The Supreme Court said Section 10 of the Act allows reference of a dispute to whether the dispute is existing or apprehended. That is enough. A formal demand letter is not necessary. The apprehended dispute would become meaningless if we require prior demand. On contract labor, the court held whether the contract is sham itself, that is decided. You cannot reject the reference and we start by saying there is no relationship. This is decided by the court whether there is relationship or not. The court relied on the constitution based in District Authority of India case, National Unions 2001 case. The takeaway government can refer a dispute even without formal demand. Contract workers can challenge signed contract. Technical objections should not deny delay justice. These are the important statement. Procedure before court and tribunal. Step 1. Party files a claim with document within 15 days of getting the reference order. Copy sent to the other side. First hearing is fixed within 1 month. Opposite party files written statement within 15 days of the first hearing. Party can file rejoinder after 15 days. Evidence date fixed within 1 month. Evidence are recorded. Arguments are heard within 15 days of the evidence completion. An award is submitted within 1 month of the argument. And then, if the party is not happy, one party is not happy, they can proceed to court, next party. Right? So this is otherwise the award is to be implemented. What is settlement? Settlement means either in conciliation proceeding or out of the court, like in arbitration, when both the parties agree to a decision, then settlement, if it is done through conciliation officer or the board of conciliation conciliation, then this is called conciliation, and all parties to dispute must agree, and they must sign, and they must get it implemented. The conciliation settlement is binding for future worker also. What are the common mistakes by HR manager? Take here one case study. Signing minutes of conciliation meeting and then saying it is not a settlement. This happens occasionally when the employer signs the conciliation meeting. The PC agrees, but later on he says, "See, this is not binding on us, or this is not a settlement. This was just a minute of the meeting, or the settlement was not published, or the person who signed was not authorized or not competent." These kinds of arguments are not valid. Once you have signed, it is valid and it must be implemented. Under Rule 37 of the Industrial Dispute Act, every party appearing to representative is bound by that Representative Act and must be followed. In the case of Life Insurance Corporation versus DJ Bahadur case 1980, the Supreme Court say that Industrial Dispute Act does not allow a vacuum rights under the settlement under a settlement continue until replaced by a new settlement or award. Settlements have the same sanctity as an award; they continue to be binding until properly terminated. Now let's come to chapter 5, which is on strikes and lockout. Strike is by workers, lockout is by management, right? Uh, in a public utility service, public utility services like electricity board, like telephone department, like post office, and they are called public utility services. Their proper notice is required. You cannot start a strike or lockout without 6 weeks minimum notice, and maximum. So without 6 weeks notice, right? Uh, you can start a strike or lockout only after 14 days of giving notice. And if the notice is given and a long time has succeeded and now it is expired, then again you cannot start strike or lockout. You cannot do strike or lockout with conciliation proceeding. You cannot go for strike or lockout 7 days of conciliation proceedings. What is public utility service? Public utility services like railway, post department, telegram department, telephone department, electricity department, water, that is PHED department, etc. Otherwise, in other companies, strike and lockouts are possible. You can, but it is not again allowed if you are doing conciliation or you are in adjudication process or arbitration is going on or within 60 days of such proceedings, like you have signed an agreement and conciliation and now you want to go for strike, that is not allowed. Layoff. Layoff is, we have already discussed, when the company, the employer uh, asks a worker not to come. That is called layoff. He says, "I cannot continue to give you job because we don't have electricity, we don't have raw material, or we don't have machines in order, and therefore there is layoff." So when there is layoff, 50% of the wages and their the money has to be paid. The condition is the worker must be on the muster roll. The worker should be regular employee. There is no compensation if the worker refuses alternative job. There is no layoff. There is no compensation if the layoff is strike by the workers or if layoff is in seasonal establishment. In these cases, there is no compensation. Retrenchment. Retrenchment is detailed out in section 25N. Retrenchment means a factory establishment. Ask the worker to leave the job permanently, and it is called retrenchment. Retrenchment, for retrenchment, 3 month notice in writing with reason and employer applies to government. The procedure is before going for retrenchment, the employer applies to government. Government conducts inquiry. Government gives hearing to employers, workers, and then government gives order. If either government gives permission, then you can do retrenchment, or the government puts some conditions which is followed. If permission is refused, then retrenchment becomes illegal. You cannot give retrenchment. If the government gives permission on the basis of genuineness of system or on the basis of interest of the workers or keeping in mind other factors, the government gives permission. And once the permission is granted, you can undertake retrenchment. Meenakshi Mill versus Meenakshi Mill case. Here, employers challenged Section 25N. They said it was unconstitutional. They compared it to the old Section 25O, which was struck down in Excel year case. The Supreme Court held that Section 25N is fine, is okay, it is not unconstitutional, right? The old Section 25O gave government uncontrolled power to refuse closure. New Section 25N has time limit 60 days for reason and need to permission if no decision is taken and reasons have to be recorded. Judicial review is allowed under new Section 25N. The court said the right to carry on business under Article 91G cannot have reasonable restrictions. Section 25N is reasonable because it balances employer rights and workers' interests. Now we come to Section 25O. It is about closure of the factory. When you are not able to run the factory, you go for closure. You have to apply to government. It is 90 days before the date of the closure. Application must state the reason for the closure. The copy should be sent to workers or unions representative also. The government will conduct an inquiry which will give both the parties, workers and management, opinion. The government passes reasoned order 60 days. If no order is given, then it is assumed that the permission is given. Right? If the government doesn't give permission, the establishment has to continue. You cannot close down. Now let us look at a case study. Harinagar Sugar Mills versus State of Maharashtra case. Harinagar Sugar Mills made biscuits for Britannia for 30 years under Jacob Work agreement. In May 29, Britannia terminated the agreement with 180-day notice. HSML had no other work. They applied to the government for closure permit. They said we want to close down because we don't have any other work now. Because Britannia company has now completely broken the agreement and now there is no other income. They gave a notice to the workers and they applied to the government for permission. On September 25, 2019, the Deputy of Government said that the application lacked details. HSML gave more details on October 10. On October 19, on November 19, the authorities again said it was incomplete. 60 days went by, no order was passed, so the permission was said to be deemed permission. The government said the application was incomplete, so 60 days did not start. The Bombay High Court agreed with the government, and the court held that ultimately the matter was taken to the Supreme Court. The Supreme Court allowed HMLs to keep. The findings were the Deputy Secretary had no authority to ask for resubmission. The power was with the Labour Ministry only. The application was completed on August 28, 2019. 60-day period started from that day. Since no order was passed for 60 days, permission was deemed granted. The decision of the Supreme Court is right to close the business is part of fundamental right to carry on business, right? But this right is not absolute. The state can impose reasonable restrictions. Okay. So the court gave cited the Excel Gear case and Visa Textile and Steel versus Visa case, and the final permission for closure of the factory was granted in 2019, right? And thereafter the factory was closed down. But the court directed HSML to pay additional 15 crore compensation to workers apart from gratuity. This extra compensation was to balance the rights of the employers in the interest of the workers. Now we come to unfair labor practices mentioned in chapter 50. Industrial Disputes Act prohibits unfair labor practices. Examples of unfair labor practices are threatening the workers, establishing employer-sponsored union, dismissing the workers by victimization, disregarding principles of natural justice, replacing regular workers with contract workers, showing favoritism, and not implementing award adjustment. These all are the cases of unfair labor practice. So, what is the punishment? Punishment is 6 months jail or fine. That is the punishment. So, these are the main provisions of Industrial Disputes Act that we have discussed. And if you have any questions, you are free to raise your questions or write on the chat box or send us an email, and we'll try